Welcome to the Exit Ready podcast. Ryan Ray here as always. Today you're going to love the episode. Be sure to never miss what's going on with the Exit Ready cohort intensive by going to www.rgahub.com/exit-ready. That's rgahub.com/exit-ready. I'll put a link to this in the description below so you can check it out. But if you're an owner, you're not going to want to miss this. Now, let's get to the show.
Kevin, it is an honor to have on, let me think here. Was it the greatest M&A attorney? We came to that event last year. It was like the greatest M&A attorney in Texas. Is that what it was?
Let's go with that, Ryan. No, it's the number. Well, in 23, the number one deal lawyer in Texas by deal count. It's important to caveat. We do lower middle market deals, so we'll never compete on like dollar volume with the big firms. But in terms of number of deals closed, and then follow up number two in 2024. So we'll see what 2025 brings.
Nice. Okay.
But
And lower middle market is what?
Yeah, we define it as $2 to $50 million. The true lower middle market probably goes into the low nine figures. We'll do larger deals. They're more rare. They're more time intensive. It's tough on the team. So we only do it when the deal really makes sense. Our sweet spot is really $2 to $50 million.
Okay, so $2 to $50 million of enterprise value or sales price okay. And so that's where most of the deals are actually, anyways. It's your point. And so a lot of people see M&A, but the M&A we hear about is Google buying some company or Nike buying something. But really, most of the deals are much smaller. But did you and Eric?
There's like 50 of those deals a year, the big ones. It's just not like they dominate the news, but it's just not the norm for the
Yeah, and I used to work in oil and gas, and so you'd hear about Exxon's buying up this company or something like that. It's like that's kind of a different world than we really live in. So it's but didn't you come from that world, you and Eric, or y'all worked there or something?
Yeah. I worked for a few different large law firms for about a decade before I went in house for a big Fortune 500 company. But that 10-year span. I mean, I did deals ranging. I think the smallest deal I ever worked on was about 20 million. But the vast majority of deals we were doing were in the 100 to, several $1 billion range.
Wow. Okay. So obviously complexity, because there's a lot of moving parts and big stuff, big companies. But what else do you see for the lower middle market, that 2 to 50 million that might carry over? So people have read the news, they have seen some of these headlines of these big deals. It is kind of true to them, or is there not much that trickles down to these levels?
There's a lot that does trickle down. A lot of people talk about like what's market. That's a little bit harder. The market really is kind of middle market and up. So that's a little more variable, but the principles are all largely the same. What you're trading with those larger deals are complexity. Oftentimes they're highly regulated, so you've got different regulatory specialists involved. There's antitrust concerns, and then just the sheer size scales differently, right? We can have one associate go do all the due diligence in, anywhere from a couple to 10 hours on a $4 million deal. That takes a team of junior associates weeks, if not months, on a $8 billion deal, literally just because of the sheer volume, right? If you're reviewing contracts, you've got maybe 100 contracts in a $4 million deal company. You may have literally thousands of contracts in a multi-billion dollar deal. So really a lot of it is the scale. You do get a lot of the regulatory complexity. And then you get a lot of kind of deal structure complexity. A lot of those larger deals are involving cross-border components, or they're coming into, international companies where you've got really elaborate corporate structures. Sorry, blanking for a second. And things like that. But that's a long way of saying the underlying M&A principles of, robust representations and warranties, a protective escrow, a robust indemnity that protects a buyer or, can protect a seller, earnouts, all those principles are really largely the same, which is, I think, part of what's led to SMB Law Group's success, because we did so many sophisticated, large deals. Like that was our life. We weren't, you know, probate lawyers that decided to do
Right.
M&A. I mean, we've been career M&A professionals that really cut our teeth on really sophisticated deals. It made it nice to transition into the SMB space and say, hey, we can bring a level of expertise here that most people don't have.
Yeah. And so you mentioned a bunch of terms there I want to unpack. So, but let's
Let's
start
do it.
first. If you're listening to this and you're going, okay, M&A attorney, I've got a business attorney, or my cousin's a divorce attorney. I always like to say, like, why do you even need an M&A attorney if you go to sell or buy, I guess, but sellers is the focus here. So sell your business.
Yep. Yeah, you're making arguably the single most impactful decision of your lifetime when it comes to finances if you're exiting a business. That may not be true for everyone. Maybe you're a fund, and you're doing a lot of like acquisitions, dispositions. But for the majority of like small business sellers, call it the $2 to $25 million range, you've built this business over a lifetime, and now you're exiting, and this is your retirement. It's your children's heritage. It's their inheritance, and so forth. And so the easiest way to think about it is if you had to do the single most impactful surgery of your lifetime, would you go to your general practitioner, or would you go to the whatever surgery, right? Whatever specialist, the orthopedic surgeon that did their residency at the Mayo Clinic and, like really, really knows their stuff. Like if it's medical, right? If your life is on the line, that answer is obvious, right? You're not going to your family doctor down the road to treat you for cancer. You're going to you're going not only to the oncologist, but probably the oncologist that's a specialist in your type of cancer, right? That's obviously the downer way of creating a metaphor here, but the metaphor is apt, right? That like this is the single most impactful transaction or financial decision you'll probably make in your life. You really want someone who knows this particular space and focuses on this particular space, that they eat, live, breathe M&A, right? That's not the general family law. That's not certainly the general practitioner, and it's certainly not a different specialist, right? You would no more go to a dermatologist to talk about your, throat cancer as you would go to a trust and estates lawyer to talk about M&A. And that's the way I explain it to people.
Yeah. So like if we were considering adoption, we call you up and you'd say, no, I can't help you with
I
that.
don't
Like,
I don't do adoption,
right.
right?
You might
Yeah.
refer to someone else that you might know who's good, but that's not really your thing. And so you do have to kind
And
of think about it. Go ahead.
I could fudge my way along if I needed to. And I think that's what
Mhm.
a lot of sellers need to be careful of when they're choosing legal counsel, is they don't choose the person that's fudging their way along and kind of figuring out as they go, or they do a couple of transactions a year so they have familiarity. That you really want the person that's performed 1,400 surgeries, not 6 surgeries, when you're
Yeah.
being operated on for cancer. It's the same thing.
Well, I mean, I called you a few months ago. Said, "Hey, I got this guy. He's thinking about selling. He wants these kind of crazy terms." And your experience was, well, you could do this, you could do this, and you kind of walk through it. Whereas an average business attorney might be well intentioned, but they might not have seen all of the ways that you've seen to structure deals. And so, even good intentions can only get you so far, because if you don't have the experience of seeing what can work, what won't work, what is doable, if you will. Because I don't want to go read all the case law. I don't want to. I don't
Well,
want to go understand all that stuff. And so, you do, though. That's kind of your background. And so I think that when we think about this, we go, well, I need a contract to get a client, to work with me. Great. Okay. I have an MSA or whatever. But when you go to exit, as you mentioned, there's a bunch of terms that you kind of threw out there because you're familiar with them. Whereas the average business attorney might be familiar with those terms in certain contexts. But when you go to exit the business, they become very important, because if like, when I sold my first company, we had MSAs, and so we couldn't
yeah.
assign those to anyone else. And so we couldn't we couldn't sell it as an asset, because those things were tied to the owner, the company. And so at least that's the counsel I got. You might say, no, I don't know. I didn't know about M&A attorneys back then, so maybe I was wrong. But stuff like that is a question that M&A attorney can help you go, oh, wait, you have these type of contracts, therefore you have to do this, or you can do this, or you can't do this. And so start with contracts. Maybe what are some of the things that you see in the world that may stop deals because sellers aren't aware of, or prohibits deals because they didn't understand their contract with their vendors or potential employees or whatever it might be that just messes deals up?
Yeah, it's It's a great question, and highlights an important point that a lot of what a good M&A lawyer does is that sort of advising and counseling, and less so what does this representation in an agreement mean. You talk about AI disrupting industries. The latter is going to be disrupted by AI. You can go on ChatGPT and drop in the text and say, hey, what does this actually mean? Right. You don't necessarily need me to explain that to you. What you do need is to be able to call up the phone and say, man, I'm running into this roadblock. The broker's telling me this, the seller's telling me this. Like, what do you think? And your lawyer can draw on, 800 deals of experience to walk through some different permutations. It's a great point. To your question, what are some of the things that we see that can be kind of roadblocks, or cause issues, especially on the sell side? Um, Indemnification is a big one. You mentioned, I threw out some words that maybe aren't familiar to everyone. The indemnification section of a purchase agreement is arguably the most important section. It's the section that governs what the recourse is for the parties if something goes wrong, right? And I'm always telling people, if everything goes great after closing, the purchase agreement was largely irrelevant, right? What we're doing is documenting what happens if something goes wrong, and so the indemnification provision becomes really important. And there's a lot of things in terms of overcommitting. How long should you be committing to trailing liability? What is the scope of liability, and particularly if you're doing an asset deal, what can you as a seller owner end up liable for, personally? Can your buyer have a cause of action back against you personally? um, any sellers who are partnerships with more than one person involved, if something goes wrong, how does that get allocated? There are some really kind of robust legal principles that favor buyers that say, if I'm a 50-50 partnership with Ryan and something goes wrong, a buyer is allowed to recoup $100,000 in damages. Conceivably, if we're not careful of how we document things, conceivably that buyer can come after me for the entire 100,000 because Ryan's already run off to Panama and bought a yacht. Right, he doesn't have $100,000 anymore. These are the types of things that keep me awake at night on behalf of my clients. So yeah, indemnity is a big one. Contracts are a big one that you mentioned. Licensing is huge. I see a lot of sellers kind of take the approach of like, hey, you're buying the business, like figure out your licensing, which, I mean, on the one hand is a factually true statement, but on the other hand, if you want a smooth transaction that closes, it's important to understand what licenses you have, and what's required to get them, because your buyer may not fully understand that, and your transaction may go a lot smoother if you're able to navigate through that. So licensing is a big one to make sure that you have your head around that. Corporate governance, I think this one's overlooked as a lawyer. I think this is probably focused on topics by sellers, but there's a lot that is supposed to be being done, especially if you're a corporation over an LLC, that most small business owners are not doing, candidly. And that poses some potential liability for the seller owners. And so making sure that you have everything up to speed on from a corporate governance perspective. I mean, I could go on for the rest of our chat
Yeah.
here if I needed to, but
No, no,
those
it's
are a couple that come quickly to mind.
no, it's great because you said if something goes wrong. Okay, so let's just start with like obviously not the whole U.S., but in the Kevin Henderson SMB Law Group world, what are the odds that something major, not minor, like hey, we found something but something's going to require legal action? What are the odds? Is it 10%, 20%, 50% of the time something major is going to go wrong?
Hey, quick break here. If you're an owner, do you know that most companies will never actually sell? That means that all those years that you put into building your business are for nothing. If you want to build a business that's valuable, that people will want to buy, and you can make potentially millions of dollars from, go to rjhub.com or click in the link below. That's rjhub.com or click on the link below. And now back to the episode.
Yeah, major is pretty low, to be candid. You're talking the single digits, right?
Okay.
And by major, we're talking about the seller defrauded you.
Mm.
You get sued for something the seller did prior to closing for a catastrophic amount. The seller blatantly violating the non-compete and putting your business in jeopardy. Those are like major issues. Those are excuse me, reasonably rare, but single digits, right? I mean, if I go look at several hundred deals that our firms close, I mean, we've got a dozen major issues that have come up, right? And they're tough to identify, they're tough to predict, especially when it involves a bad actor. So I don't want to scare people off that it's huge, like 1 in 5 chance you're just going to get totally stabbed in the back. That's not generally been my experience. But it's also not a fraction of 1%. I mean, it's sizable enough that you need to do everything you can to protect yourself as much as possible. What we see a lot more of are kind of the like minor league infractions, right? Things weren't exactly as seller purported them to be. There are a lot of things you can do as a seller to make in the kind of run up to a sale, to make your business look a little more attractive than it is. That isn't fraud, but is it the full picture to a buyer? Probably not, right? We tell buyers clients this all the time. um, if you're buying a business from a seller that's been running the business for 30 years, you're never going to be able to diligence that business to the level that the seller knows where all the skeletons are buried. You just can't. They've got 30 years of experience, and they know all the nuances, and so you're trying to protect yourself as best you can. And I'd say it's really those kind of minor league things, the kind of moderate issues, that are probably the ones that should have more buyers worried about deals, rather than like the big catastrophic things. I find that most sellers, everyone's advocating for themselves, but usually things don't arise to that kind of major level.
Right.
Knock on wood.
Well, and I think this goes back to what you're saying a minute ago, which is that if you bring the right team in, you have the right experts, your odds of something, going wrong goes down dramatically. But if someone just comes in your office and says, "Hey, what's your revenue? What's your net? Let me give you a check right here," which doesn't happen, but if it did happen, the odds of something going wrong are really high then. So, M&A is a high stakes game, which is why you got to have the right personnel to help you go through this process. Otherwise, you are setting yourself up to be vulnerable. And so,
And I
you know,
think,
go ahead.
and sorry to interrupt, I think that's what sellers need to be most worried about. And I wish I saw sellers do more vetting of buyers, because the the likelihood of a seller being sued for some claim after closing goes up exponentially if you have an inexperienced buyer or a poor operator, right? Because they're scrambling to find anyone to cast blame at, even if you didn't necessarily do something wrong. If the business is taking a nosedive in performance, there's an incentive to find every possible finger to point at someone else, and the seller is ripe for that. So that I think sellers do themselves a disservice when they don't do a little more vetting of like, I may not have that much of a vested interest post closing in this buyer, but for the fact that I'm going to end up sued if they are a terrible operator, and I want to be
Hmm.
sure that this is the right person to carry the business forward.
So, if I called you up and I said, "Hey, I'm going to sell. What are your thoughts on earnouts?" I know you don't know enough about me to kind of give me like the proper advice in this case, but generally speaking, are you pro earnouts, limit earnouts? I understand that if I don't take an earnout, I'm going to lower the cash value probably on close. But what would you say to me about earnouts?
As a lawyer, I would say it depends, Ryan. Uh,
Okay, I knew you were going to say that. Between
I,
me and you here on this chat.
I will say this. From the seller's perspective, um, earnouts can be a great tool to get additional compensation after closing. What I generally tell sellers, though, is to transact at a level that you're comfortable enough if the closing consideration is the only thing you ever see. Earnouts are by far the most highly litigated part of M&A deals. On both sides, candidly. Sellers litigate just as much when there is a legitimate, failure to meet an earnout hurdle, just as much as buyers are to play games to keep an earnout down. Again, I don't want to scare people that the amount of buyers out there like committing fraud that are just like playing games to not pay earnouts. That's pretty rare, right? But it does happen with enough regularity and not even necessarily in bad faith, right? Just buyers implementing new policies, procedures, business practices that they think are going to grow the business that don't pan out the way that they hope to. And so sellers need to at least analyze the deal, that any upside is true upside. And if it's a $5 million cash purchase at closing and up to $1.5 million of earnout, am I comfortable and happy if when all the dust settles, I've only walked away with that $5 million? If I'm not happy with that, I need to be rethinking the deal structure and the deal valuation, just because they are highly litigated. There's a lot of things buyers can do in the business that can cause a failure to meet an earnout. Like I said, even if it's not bad faith, and usually a
Yeah.
good buyer and buyer's counsel is going to craft an earnout in a way that gives them cover to take legitimate uh, business steps and practices and things like that, as long as it's not intended to avoid an earnout, and they're actually trying to grow the business, but it doesn't actually pan out, then there's no liability for the buyer. So yeah, that's kind of my take on earnouts is, if you think, I think there's a narrower band of where they make sense. And that's usually going to be a business that's being sold in a pretty, steep upcycle. Buyers just cannot responsibly pay a multiple on trailing 6 months EBITDA. You just can't. Right. So if you're really in a period of growth and you believe wholeheartedly that that's going to sustain, but a buyer's got to look at like 3 years trailing average or something like that, to protect against some downside, then an earnout could make sense. But you just got to be comfortable that you may not see it.
Now, I think you hit the nail on the head. You got to be comfortable with what you get on date, like closing day, and then you want and you hope, and you whatever your role is to get the earnout to be earned, you can be a part of that. But you've got to be comfortable with the 5 million. I think you said,
Yeah.
because you might not get that, and then you made a point a minute ago about the business owner who's owned it for 30 years and all the skeletons. Well, the new owner is going to understand how to potentially hide that. It doesn't mean that they're going to have ill will and try to not pay you. But it also doesn't mean that they go, wait, I got to pay $1 million this year. But man, if I had $1 million the next year, I could make 3 or 5 million, and try to
Mm-hmm.
manipulate that in a way, just like you might do as the owner now. It's always tell owners, look at the perspective from a buyer. Like what might you do if you were going to buy? And so it's not necessarily, from the new owner's perspective, if they got to pay this earnout, it's $1 million, let's use a term, and they go, man, if I had that $1 million, man, the next year we could really grow. But if I don't, we're going to stagnate. And so,
Yeah.
as the current owner, what might you do? You might try to not do that. And we've seen plenty of owners who have done stuff for taxes and stuff like that to lower their income level. So it's not necessarily trying to cheat, but it's just how business owners think of how to maximize profit, how to grow the business, how to keep things going. And so those things come into play. And so you got to make sure that you have the right advice and understand how you would audit and stuff like that. And so I think earnouts are, if you're talking about selling a PE, obviously that's a different kind of animal. That's almost going to be, they're going to expect you to come on board and stuff like that. So your exposure to watch it. But if you're selling to a strategic or to a one-off buyer, it's probably a little bit different. Maybe unpack that. Like if you are selling to PE, because PE gets thrown around kind of like those big M&A deals, but there's really small PE groups that we've never heard of that are out there that are buying up companies. So if someone goes, well, should I sell to PE or the random buyer who comes after me? How should they think about those two different avenues?
Yeah, it's a good question. And it depends a lot on kind of motivations for selling and what you want out of a deal. If you are selling for a financial exit, you want to maximize your return, etc. Um, selling to PE is attractive, or at least it can be, right? Unless you're a new platform and then they want you to stay on and roll a significant portion of the purchase price, and then maybe that's not the exit you're looking for. So I really think it's the two scenarios. If you want to maximize your financial exit and you're selling into an existing platform, individual buyers just can't compete with multiples that private equity can pay. They just can't, right? My business school friends love the word synergy, and I hate to use it, but there are a lot of synergies in rolling a company into an existing platform that allows a PE buyer to pay higher multiples than, say an SBA backed or first time independent sponsor is ever going to be able to do. Um, that said, they're going to change a lot of things in the business, right? I still see a lot of sellers that rightly or wrongly think about their business as quasi family. They want their people taken care of. They like the fact, right, that I was just reading on X the other day, uh, or I think it was a podcast. It was a podcast I was listening to the other day, where the guy's not a private equity fund, but he's built a very successful holdco, and he was explaining that like he had an employee who was a long time, really dedicated employee who I think a family member got cancer or something, and the company was able to pay for the treatments, and he's like, I never could have gotten a private equity board to approve that, like ever. But that's what I wanted to be able to do with my company. So again, it depends on what you're wanting to do, what you want for the company, where you see. Rightly or wrongly, it's easy for people in my seat to say, "Oh, I mean, you're selling the business. What do you care?" And you shouldn't think about employees like family. They're not your kids, but a lot of people do, and there's nothing wrong with that. And if you think you can align your values more with another individual buyer that just happens to be 20 years behind you in career but is going to think about your business as family, there, that's fine. There may be some financial trade-offs. So that's kind of how I think about it, is like, what are the incentives, and who is the right buyer to execute on that vision. And like I said, if you're looking for that exit, you want that cash in the bank and like sayonara, best wishes in the future. PE can be really attractive. Or you just realize you were a good, $1 to $5 million founder, but you're not the guy to take it to $50 million, rolling into a platform where you can continue, maybe in that case you want to roll equity and you want to continue to get upside and you want to continue to work. You just know that partnering with a platform is going to take you a lot further. That's the other time you're going to look at private equity. You're gonna have a lot harder time doing that with the random Main Street buyer down the street.
Yeah, no, okay. So you mentioned non-competes a minute ago. I want to circle back to that because was it last year before last, the non-competes got banned, and so there's a lot of confusion around that. So first off, they're still in play for owners. So if you sell your business and they ask you to sign a non-compete, which if they've got good counsel, they will. So you got to sign one. Is it 5 years? Is that the expectation?
That's the norm.
Okay.
Usually, especially on the SBA side, we see most banks with a minimum of 3, but 5 is kind of the expectation, and there'd have to be a compelling reason to do less.
Okay. So if I'm listening, okay, I say, okay, I got a 5 year non-compete. Um, but if I'm a plumber, just use a term. If I'm a not a plumber because they got state licenses, but if I'm someone in DFW area, I sign the non-compete. But once I sell, I'm going to move to Michigan, and I'm going to live in Michigan. Does the non-compete, is it U.S. based? Is it really that broad? Because I know for like employees, when we had it's
Yeah,
like okay, they could
it
challenge
depends.
that. Go ahead.
Yeah, it depends. The way that and this is an important caveat, that non-compete laws are state statutes, and so the laws vary by state. But there are some general principles that are hold mostly true, and that is that in most states, a non-compete, in order to be enforceable, has to be reasonable both in duration and scope. So most states have interpreted in the context of a sale of business that 5 years is reasonable duration. That's why that's kind of become the norm. Scope varies widely, and it's important to understand that non-competes and the reason that they you know there's a movement to kind of ban them in certain contexts, mostly on the employment side, but not on the business side, is that a non-compete really is not intended to be punitive. It's intended to protect intellectual property. That's what its intent has always been, right? And so you say, hey, if I'm hiring you, Ray, to build this special piece for a rocket, I can't afford to have you leave my company, Northrop Grumman, and go to Lockheed with all of that knowledge and start building the piece for Lockheed. Therefore, I'm going to impose a non-compete on you that says you cannot go work for a competitor and take that specialized knowledge. I can't impose a non-compete that just says, hey, Ryan, you're a secretary and I'm going to impose a 3-year non-compete just because I don't like my competitors, so I don't want you to go help them or work for them, right? You have to actually be protecting a legitimate interest. And so why do I give that background? And sorry for the long-winded answer. The point is that if you are selling an HVAC company in DFW, there is no legitimate business interest that you are protecting in Detroit with a non-compete, right? You only do business in the DFW area, maybe slightly beyond, right? And so a nationwide non-compete for an HVAC sale and install company based in DFW would be way too broad geographically, and no court in Michigan or Texas would enforce that in Detroit, right? Um, Conversely, if you sell an e-commerce business that's supplying supplements on Amazon FBA store all across the country, that's a different story, because if you uproot from DFW and move to Portland, Maine, it doesn't really matter where you live. You are competing with that business everywhere in the country. So in that case, you may actually have a nationwide non-compete. So lawyers take a lot of heat for "it depends" answers, but it really, really does depend. And it's important to understand the metes and bounds and have a correctly crafted non-compete, because in some states, again, this varies by state, in some states, if you have a non-compete that's too broad and unenforceable, the entire non-compete gets thrown out, right? As opposed to other states have rules that say, hey, if you have too broad of a non-compete, that the court is just, when you're trying to enforce it, the court is just going to revise it and say, hey, nationwide is too broad, but 50-mile radius around DFW is fine. And so you're trying to compete in Rockwall, we're going to enforce it against you, even though nationwide was too broad. There are some states where if they're trying to compete 10 miles away in your home territory, but your non-compete was drafted to be anywhere in America, it's unenforceable. Boom, the whole non-compete's out and all bets are off, right? So you got to be really careful with non-competes.
And to be fair, I love the "it depends" answer, because I've had clients call me and like, "What do you think about this?" I'm like, "I'll tell you what I think, but if they sue or you sue, don't call me, because
Yeah, because it
I'm
depends.
not even an attorney. Like, I'll give you what I've seen before, but my opinion is worthless on this issue. So
Yeah.
maybe you should call." I can see something go, "Yeah, you might should talk to an attorney because that looks kind of weird, but is it going to hold up? I don't know." I think a lot of people in the space, to your point earlier about we're talking about attorneys. A lot of people in the space in general will give kind of legal advice or tax advice or advice. It's like, no, 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 no. Stay in your lane and
Yeah.
master that lane, because this is a very, very important process, especially to the seller or the buyer. And if you try to start being a master and jack of all trades, you're really going to fail. And so, like, you probably understand a lot about, tax implications and stuff like that. But I would guess you're probably going to also want them to talk to a tax expert or stuff like that. So there's a lot of stuff that you can know, but to be an expert to get the nuances, and that's where the "it depends" answers come in, because you begin to understand, like you were just saying at the end there with the non-compete. Well, it does depend on the state, on how it's written
Yeah.
and stuff like that. And so it
Yeah.
really does depend.
Yeah. Yeah, and for seller, I don't want to lose track of the non-compete discussion for sellers either, because in the business sale non context, this is far more a buyer protection. But one of the things that can make your business attractive for a successful exit is making sure that you have effective non-competes where they're allowed and needed within your own company. And so understanding these puts and takes and knowing what you're going to be restricted from doing, it can help you get ahead of, is okay, if I want to exit 2 years from now, then I want to start revamping my onboarding paperwork as I have employee turnover to kind of tighten these covenants up and make sure that when buyers are shopping my business in 2027, they're very comfortable that my main sales guy can't take my sales list across the street to a competitor the day after closing, because
Yeah.
that is a huge risk. The business sale non-compete only restricts the selling equity owners of the business. It does not restrict the employees. And so if we don't have those in place, prior to closing, it can make your business kind of unattractive. So, yeah.
Okay, so I know size and complexity of the company matters here on some level, but generally speaking, what's kind of the advice on like to get your contracts reviewed, to understand all the kind of the legal stuff is set up right? How much time do they need just to kind of get that portion? Not if they have an LOI, but like they're thinking about it. How long does it take to kind of right the ship if it's not, or just get an audit done and see if it's even ready to go to market?
Yeah. Yeah. Getting kind of a quote unquote audit done and like taking a look at things and looking at your corporate governance to figure out what needs to be cleaned up, reviewing contracts to see what needs to be tightened up, et cetera. Doesn't have to be a heavy undertaking. It can be, anywhere from a few to several hours, right? Over a couple of weeks, right? Where the rubber meets the road is what comes out of that audit. So let me just use like a simple example, right? If you are an HVAC company that is selling monthly recurring revenue, right, like maintenance plans or something like that, and you've got 900 customers on an annual maintenance plan for $399, and the terms of that the terms of that agreement, the recurring revenue agreement for that annual contract, don't allow for assignment. Well, that's a big problem. That means you have 900 contracts that you have to go get consent to assign at closing. That said, it's an easy fix. You can swap out that assignment language that says, hey, in the event of a sale of all or substantially all of the assets, we could freely assign this contract to a new buyer. Well, that's all good and fine, but you don't want, again, to go out to 900 customers right now and say, hey, by the way, we're revising our terms of service. So you want to get ahead of that at least a year in advance so that if you're looking at an exit in early 2027, I can look at all of your agreements today, identify this issue, work with you to update the terms of service, and deploy that internally to replace your old agreement for every renewal going forward for the next year. So that 12 months from now, in December of 2026, every annual recurring contract has now been replaced and has that assignment language. So when I go to market the business in January of 2027, boom, no problem. I can do an asset deal. All 900 customers are freely assignable and no problem. So the audit really isn't the concern. It can be, a couple of thousand to, maybe the low teens to like really dig in the weeds and really unpack your business and things like that. Then from there, what we discover, may or may not incur additional fees and may or may not have some longer lead time. But all that's to say, if you spend a year figuring out what those things are, implementing changes, cleaning things up, it costs you $10,000 to $20,000 just to make up a number or whatever. And this allows you, when you go to market in January 2027, to get a tenth of a turn of EBITDA extra because your business is just that much more attractive. A tenth of a turn of EBITDA on $1 million, you just made yourself $100,000 by doing a little legwork up front with kind of minimal legal investment. So it's I don't want to be too salesy here, but it can be a little intimidating to want to spend that money that early on when you're preparing to sell. But the knock-on effects when you actually go to market your business can be exponential.
Well, and that's why I'm so excited about the intensive, because we got 10 weeks, and each week, each person, and we're going to ask you what you're going to present on here in just a second, but each week, just the information that they're going to get is going to be potentially, it's up to them, they have to go do it or, follow up and do the work, but it's so much value because this is a high stakes game. This is, you mentioned turns of EBITDA, and so some advice they're going to get might increase their multiple by a whole turn, right? Some might be a tenth of a turn. And so, all this stuff goes from, if we go back to what we said a minute ago, what do you want to get on day of closing? Well, if you're worried about that earnout potential, but you went from $5 million on day of closing to $6 million on day of closing, and the earnout still is whatever it is, that's $1 million. That is $1 million, or 500,000, or 2 million. There's a lot of little things. Like I have one customer right now, and customer concentration is killing the value, but they're
Yeah.
ready to exit. And so it's like, okay, well, they're going to take they're going to take a haircut because of that, a severe
Yep.
haircut. And so that kind of stuff, it's like, okay, in this game, this is not a game of, $2.99 monthly subscription. Like this is a game
Yep.
where hundreds or thousands or millions of dollars are on the line. So, what will you be talking about on your week, and what could people expect?
Yeah, I've hinted at a few already, but yeah, I mean, we're going to talk about basically what are all the red flags that a buyer is going to see in your business is kind of the approach I'm going to take. We're going to talk about governance. Like I mentioned earlier, a lot of people don't appreciate what they have to be doing for some of the protections and liability protections and things like that for your business. So how can you audit that and get on top of that? What to look for in customer and vendor contracts as a potential seller, so that you can start to get savvy about what should I be updating in advance of a marketed sale. Intellectual property, I think a highly underrated category for small business owners, where you can really make your business more attractive with some really basic intellectual property protections. How many sellers listening to this video right here have never even thought about exploring a trademark for your business? And could that be valuable on exit, to know that you have some brand equity, and that brand equity is protected by a trademark? That could be really easy, low hanging fruit. So we'll talk about intellectual property protections, not just trademarks, but other things that you could do to increase the attractiveness of your business. The employment side of things, what are our kind of best practices in employment, in employment, that you can be thinking about adopting, and rolling out again, to make not just the business more attractive to a buyer, but also limit the risk of a buyer. I'll tell you, representing hundreds of buyers over the last several years in this small business space, their number one concern is not that a seller's defrauding them, is not getting sued by a former customer. It's closing their business and losing a key technician or salesperson 3 weeks after closing. That is the by far the number one concern of buyers. And so, what are some things you can look at doing and adopting and kind of taking care of internally, whether that's restrictive covenants or incentive type things, to try and alleviate those concerns and make your business more attractive as well. But broad base, those are kind of the key categories I'm gonna be looking at, and then we'll probably spend a little bit of time just talking about the transaction process itself and what to expect, so that sellers can kind of go in armed with a little bit of knowledge, whether that's next month or 2 years from now, of what are the big ticket items when I'm approaching an M&A transaction that I want to make sure that I protect myself on. So we'll do a little bit of transaction talk as well.
Awesome. Well, Kevin, I am looking forward to it. And hopefully 2025, you are back at number one where you belong. And then
Hoping
2026
so.
and 2027 and so on. And so it's been great to get to know you and the SMB Law Group. And so you guys are doing great work. And so excited to have you part of this. And so looking forward to this. And I don't think we've pinned down your date yet, but we will pin that down. And then when this comes out, we will share that with everyone so they know
Sounds great.
when you're talking. Thank you so much for your time today, brother.
Absolutely.